Honorable President of the European Court of Justice, dear Professor Lenaerts, Excellencies, distinguished guests, dear students, colleagues, and friends. It is a great honor and a sincere pleasure to welcome you to Humboldt-Universität zu Berlin for another edition of the Humboldt-Reden zu Europa. I am delighted to address you today on behalf of the Presidium of our university. This lecture series has become a well-established and highly valued forum to engage with the fundamental questions shaping Europe today. These questions concern our political system, our legal frameworks, and our future as Europeans. Dear Professor Lenaerts, we are delighted to have you with us and are very much looking forward to your reflections. Your voice is central to European legal conversation, and it's a great privilege for our university community to engage with your perspective today. The Humboldt-Reden zu Europa stand in a long tradition at our university. They provide a platform for prominent European voices from politics, academia, and civil society. What makes this series distinctive is a clear purpose. These lectures are not merely academic contributions, but impulses for public dialogue, for an open and sometimes challenging, yet always constructive debate about Europe and its future. And there are good reasons why this is fitting that the President of the European Court of Justice is speaking to us today. The Faculty of Law at Humboldt-Universität is undoubtedly one of the most highly regarded and influential in the Federal Republic. Our colleagues serve in constitutional courts. Professor Eifert is with us today. They are involved as experts in legislative processes and are valued advisors in the major legal issues of our time. Graduates from our faculty will take on positions of responsibility for which the framework conditions are currently being defined. The jurisdiction of the European Court of Justice is of great importance in defining the foundations of the EU and ranks among the greatest achievements of the European Union. The European Court of Justice ensures that EU law is applied comparable and equally efficient in its ways in all EU member states and that EU countries and institutions comply with EU law. The European Court of Justice represents the member states' living commitment to the principle that prosperity and social progress in cooperation between states can be based on the power, not on the power of the strongest, but on a system of political leadership bound by law and justice. For this reason, we should not be afraid that international treaties concluded by the EU are being reviewed by this very court. We are living in a time in which the European Union is confronted with profound and often contested transformations. Questions of mobility, climate change, democratic legitimacy, and social cohesion are debated with renewed intensity. At the time, Europe remains a unique political and legal space that is continuously shaped by dialogue between institutions, member states, and citizens. Against this background, the title of today's lecture could hardly be more timely. Citizenship in Motion, Striking the Balance Between Union and Nation. European citizenship is one of the most tangible achievements of European integration. It enables freedom of movement, participation, and protection across borders. Yet it also challenges established notions of political membership and sovereignty. The balance between union and nation is neither static nor self-evident. It must be constantly negotiated legally, politically, and socially. The question raised by this topic go to the very heart of the European project and its shared endeavor. How can unity be strengthened while preserving Europe's rich diversity? How can individual rights be protected while respecting national democratic traditions? And how can European integration remain legitimate and resilient in the eyes of its citizens? These are not only questions for courts and institutions, they affect everyday life across Europe, from students and researchers to workers, families, communities whose lives increasingly transcend national borders. They also concern us deeply as a university, committed to a critical inquiry, international exchange, and democratic values. At Humboldt-Universität zu Berlin, we understand ourselves as a place of open and critical discourse. People from many countries and disciplines come together here to learn, to research, and to question established assumptions. Events such as the Humboldt-Reden zu Europa help us not only to discuss about Europe, but experience it in its diversity, its tensions, and its possibilities. I would like to express my sincere thanks to Stiftung Mercator. Your generous and long-standing support makes this lecture series possible. It demonstrates how essential strong partnerships between academia, civil society, and foundations are for creating spaces of exchange, reflection, and mutual understanding. We are deeply grateful for this continued cooperation. I would also like to thank Dr. Spieker and his team on behalf of the Presidium for organizing the conference within which the Humboldt speech is taking place this time. Dear Professor Lenaerts, we are very much looking forward to your insights and reflections. Your contribution will undoubtedly enrich our understanding of European citizenship as a dynamic and evolving concept, and of the delicate balance that sustains the European Union as a community of laws and values. I wish us all an inspiring lecture, a stimulating discussion, and ideas that will surely resonate well beyond this afternoon. Thank you very much for your attention.
Dear President Lenaerts, distinguished guests, dear students, ladies and gentlemen. On behalf of the Mercator Foundation, I would like to warmly welcome you to the Humboldt speeches here in Berlin. I would also like to thank the Walter Hallstein Institute at Humboldt University for organizing this event and for our long-standing and trustful cooperation. President Lenaerts, it is a true privilege to have you with us today. As President of the Court of Justice of the European Union, you are at the heart of a legal system that people encounter in their everyday lives, when studying, or when working abroad, or when claiming social rights. The title of your lecture, as we have already heard, speaks directly to a central tension of our time. The European Union is under immense pressure from both inside and from within. Long-standing certainties no longer provide guidance. At last week's World Economic Forum in Davos, one message resonated time and again. A new era has begun. An era that places the European Union under multiple simultaneous constraints. At the same time, cracks are becoming visible in the democratic resilience and social cohesion within the EU and within its nation states. Against this backdrop, the state of the rule of law in the European Union and its member states is of great importance. Its erosion or its gradual consolidation directly affects Europe's stability and its ability to act beyond its borders. However, stability and ability to act cannot be based solely on institutions. This raises a key question. What truly unites the people of the European Union? In times of uncertainty, people seek a sense of belonging, they seek community. EU citizenship, therefore, extends well beyond legal status. It carries two key promises: the promise that rights move with people in the European Union, and the promise that unity and diversity strengthen one another. If European citizenship is understood as a lived reality, then it is not just an abstract principle, but it requires tangible spaces, dedicated actors, and responsibility. And this is the understanding that guides our work as Mercator Foundation. It shapes our commitment to creating spaces for pan-European exchange and alliance building within civil society, including with partners in countries seeking to join our community, to embedding the public interest in the digital economy, to implementing climate policy in a socially just manner, and to fostering constructive dialogue across differences, thereby strengthening social cohesion. Those are questions that touch the very heart of the European law and its lived reality. And there are few voices better placed to shed light on these questions. And this is why we will be looking very much forward to your reflections, Mr. Lenaerts. The floor is yours.
Mr. Vice President of the University, ladies and gentlemen, dear colleagues, friends, it's a real pleasure for me to be able to address you today on the topic Citizenship in Motion, striking the balance between union and nation. It's a very important and topical subject matter, which in fact comes just after the Windy Roads Conference organized by this Humboldt University. As is widely recognized, but worth recalling, the European Union was conceived as a peace project. In that respect, it is not value neutral. Peace and prosperity can only be achieved and maintained by creating, as the treaty says, an ever closer union of European democracies which uphold the rule of law, protect fundamental rights, and are willing to help each other in attaining common objectives. Willing to help each other, already the value of solidarity. The Union is founded on the values of respect for human dignity, freedom, democracy, equality, the rule of law, and respect for human rights, including the rights of persons belonging to minorities. These values are common to the member states in a society, we discussed it in the conference, in which pluralism, non-discrimination, tolerance, justice, solidarity, and equality between women and men prevail. This follows, you have of course recognized it, from Article 2 of the Treaty on European Union. And now an image which I borrow from a private conversation with Armin von Bogdandi here present. Just like the EU flag, which features a circle of 12 stars on a blue background, which symbolizes unity, harmony, and interdependence, ein Miteinander für die Deutschsprachige, between the peoples of Europe. Those 12 values that I just mentioned operate as the moral compass that helps Europeans navigate through uncharted waters. They underpin a certain ideal of what the member states and their citizens must strive to be and to become. We Europeans firmly believe that every human being deserves to be treated with equal dignity. Pursuing the aim of an ever closer union raises the question of how the values of the European Union interact with the values and autonomy of each member state. Today, I would like to address that question in the specific context of EU citizenship and member state nationality, in the light, of course, you wouldn't expect differently from me, of the case law of the Court of Justice of the European Union. And I would like to do so by exploring the building blocks necessary for establishing a robust and stable concept of EU citizenship, as well as the approach adopted by the Court of Justice in fostering that stability in a context where EU citizenship remains closely intertwined with member state nationality. Accordingly, the first four movements or parts of my speech examine the building blocks relating to the rule of law, democracy, solidarity, as well as the interplay concerning the acquisition and loss of nationality, while the fifth part intends to highlight the stone-by-stone approach of the Court of Justice of the European Union as developed in its EU citizenship case law. Finally, a brief conclusion will support the contention that EU citizenship, while being in motion, as the title of my speech suggests, evolves slowly and steadily with constant consideration of the consensus required when the Court of Justice takes its decisions. In this regard, the task of balancing union and nation is not primarily one of conciliation between two antagonistic poles, but rather one of grasping the structural interdependence that characterizes the relationship between the European Union and its member states. So the first building block, the rule of law. The status of EU citizen confers a series of rights upon nationals of the member states. There is a clear link between the effectiveness of those rights and the need for national courts to be strong and independent, that is to say the law without fear or favor. Without independent courts, the status of EU citizen would be next to void. For example, where national authorities decide to expel an EU citizen or one of his or her family members on grounds of public security, the court of the host member state is called upon to balance the rights to free movement of the EU citizen concerned against the need to protect the society of the host member state. I'm referring here to a judgment in which I've been sitting at the time, Grand Chamber judgment of the 23rd of November 2010, Tsakouridis. And there the court said, the assessment, that balance, entails that the threat that the personal conduct of the individual concerned represents to the fundamental interests of the host society on the one hand must be weighed against the protection of the rights which Union citizens and their family members derive from Directive 2004/38 on the other. So it's that balancing I'm speaking of. In striking that balance, the national court, that is the national court of the host member state, must guarantee the right to effective judicial protection of the EU citizen concerned or of his or her family members as enshrined in Article 47 of the EU Charter of Fundamental Rights. That was made clear in the seminal judgment in ZZ, which concerned, that's a 2013 Grand Chamber judgment of the court, which concerned the decision refusing an EU citizen admission to a member state. French citizen refused admission in the UK, at that point a member state, on public security grounds. In that case, the Court of Justice held that, I quote, "It is incumbent upon the member states to lay down rules enabling the national court entrusted with review of the decision's legality," that is the decision not to admit, legality, to examine both all the grounds and the related evidence on the basis of which the decision was taken. That court must have access to confidential documents on which public authorities based their decision. More recently, in the NW classified information case, the Court of Justice confirmed the ZZ line of case law, holding that Article 47 of the Charter does not require the competent court, I quote, to categorize certain information as non-classified and to disclose of its own motion that information to the applicant, in the event that it considers that that categorization is unlawful. However, the court wrote, in order to ensure that that person's rights of the defense are respected, that court must, where relevant, draw the appropriate conclusions from any decision taken by the competent authorities not to disclose all or part of the grounds for that decision and the evidence relating thereto. What is important here is that in balancing the rights to free movement of the EU citizen concerned against the need to protect the society of the host member state, the national court, and I repeat, it is the national court of the host member state, may therefore reach the conclusion that the competent authorities failed to comply with the principle of proportionality, or that the decision at issue constituted an unjustified limitation on the EU citizens' exercise of the right to respect for private and family life enshrined in Article 7 of the Charter. Since that outcome may not be of the liking of the government or the legislator of the host member state, or may not find support in public opinion, EU law requires national courts to be insulated from external pressure in striking that balance. And here I pause to stress how crucial it is. It's the court of the host member state which may have to rule without fear or favor in favor of the out-of-state national who makes use of his or her free movement rights against the waves of public opinion, social media, pressure of the party supporting the government, etc., etc. You see what I mean? That is why the Court of Justice cares for the independence and impartiality and the establishment by law of the national courts. Without independent and impartial national courts previously established by law, there is no EU law whose primacy, direct effect, and its application to court can be guaranteed. It all shows that the rights attaching to the status of EU citizens must be accompanied by effective remedies which can only be provided by independent and impartial courts. So I stress the point that when the Court of Justice, since the Portuguese judge's case, is emphasizing the need for national judiciaries to meet the standards of the rule of law as a common value in Article 2, this is not a concern of the court to do a sort of competence overreach, übergriff. No, it's simply a prerequisite for living together interdependently within a single common legal order whose identity rests on the values of Article 2, as the court said it in the conditionality judgments, full court judgments of the 16th of February 2022. The second building block. In order to understand the democratic dimension of EU citizenship, one must understand the two levels at which the value of respect for democracy operates in the EU level. Because indeed, next to the rule of law, we have the value of democracy, the second building block of my analysis. On the one hand, democracy underpins the EU institutional design by vesting the European Council, the Council and the European Parliament with democratic legitimacy. That flows directly from Articles 10 and 14.3 of the Treaty on the European Union. The Court of Justice has on occasion been asked to examine the limitations on the rights to vote and to stand as a candidate in European and local elections. In the Delvigne case, a Grand Chamber judgment of October 2015, the court held that EU law does not oppose national legislation that excludes EU citizens who were convicted of a serious crime from voting in European Parliament elections. This was because such legislation constituted a proportionate restriction on the fundamental right to vote within the meaning of Article 39, second paragraph of the Charter, since, I quote, it took into account, that is this national legislation, the nature and gravity of the criminal offence committed and the duration of the penalty. Moreover, the EU citizen concerned could request the lifting of the additional penalty of loss of civic rights leading to the deprivation of his right to vote. I draw, because I see many students in the room, your attention to that Elvigne case. In my view, academia has so far underexploited that case, because this is a case independent from free movement. It's relating to a static citizen whose right to vote for the European Parliament is being protected in his own member state. And that triggers the question, how could Article 39, paragraph 2 of the Charter kick in, to say it in modern language? It could, because there is the Act on the European elections adopted by the Council, and that act is being implemented by the member states organizing the European elections. And there you have it, Article 51.1 of the Charter. When member states implement union law, in this case the Act on the European elections adopted by the Council, they are in the substantive reach of union law, implementing union law, and therefore Article 39, second paragraph of the Charter kicks in. So the Court protects the right to vote in European elections of all EU citizens, both mobile ones and static ones, what we discussed earlier in the conference. But there are limits. By contrast, in Commission against the Czech Republic and Commission against Poland, the two judgments of November 2024, Grand Chamber, the Court found that those two member states had failed to fulfill their obligation under Article 22 of the TFEU by preventing EU citizens who are not nationals from becoming a member of a political party or political movement. So that case is limited to migrant, to mobile EU citizens. So the Court found that the two member states breached Article 22, TFEU. And that was because EU citizens were not afforded equal access to the means available to nationals of the Czech Republic and Poland, respectively for the purposes of exercising the rights to vote and to stand as a candidate in European and local elections. The Court rejected the arguments put forward by the Czech Republic and Poland, according to which it would be contrary to the protection of national identity enshrined in Article 4, paragraph 2 TEU, to allow EU citizens who are not nationals to become members of political parties, since they would exert influence over the outcome of presidential and national parliamentary elections. The Court accepted, however, that the organization of national political life, to which political parties and political movements contribute, is part of national identity within the meaning of Article 4, paragraph 2, TEU. And in that sense, presidential and national parliamentary elections fall outside the scope of Article 22 TFEU. This provision, providing the possibility only to vote and to stand as a candidate at municipal elections in the member state in which an EU citizen resides, and in the elections to the European Parliament. It follows, the Court said, that this treaty provision does not oppose national rules that preclude EU citizens who are not nationals from taking part in the decision-making within a political party or a political movement regarding the nomination of candidates in national elections. But Article 4, paragraph 2 TEU must be read in the light of provisions of the same rank and cannot exempt the member states from the obligation to comply with the value of democracy enshrined in Article 2. So, The global picture is that the court protects, when a case is submitted, the court of course never takes the initiative itself, the functioning of the democracy at the level of the EU Parliament and of the local level, the only levels which are caught by substantive union law, and then protects for the elections to the European Parliament all EU citizens, both static and mobile ones. On the other hand, national democracies, and it needs really to be emphasized, national democracies play an essential, I would almost say an existential role in European integration and thus in European democracy itself. That is why the European Union is composed of states which have freely and voluntarily committed themselves to the common values referred to in Article 2 TEU. And I quote there the Republica judgment of Grand Chamber judgment of 2021. It is in keeping with the value of democracy that a candidate state for membership may join the EU, Article 49 TEU. Similarly, it is in the light of that same value of democracy that a member state may decide to withdraw from the EU, as the Brexit example shows, and I refer here to the Grand Chamber judgment of even the full court judgment in the Whiteman case. In the context of democracy, I would like to emphasize that in the EU legal order, democracy is an inclusive concept. From my perspective, what I'm now saying is the most important of the whole speech. Democracy is an inclusive concept. The population as a whole counts, not just the majority. Already, James Madison, in the Federalist Papers, 230 years ago, spoke about the tyranny of the majority. The minority, the opposition, are not enemies of the people. And I say this because now you even read in respectable media that there would be an opposition between democracy and rule of law. These remarks start from a fundamentally wrong premise. Democracy is demos kraitein. The people govern, but the people is the whole of the people. That's why Jürgen Habermas speaks about deliberative democratie. If there were no different standpoints, pluralism, tolerance, inclusiveness, non-discrimination, you don't have the people as the basis for the kratein. So it is an inclusive concept. The whole population counts, not just the majority. Respect for the value of democracy means that minorities cannot be pushed aside or be discriminated against, and that the courts must be strong in protecting their rights, even if that protection leads, as I already said, to a negative reaction. Only strong courts can protect minority rights. The protection of minorities is where the rule of law and the democratic dimension of EU citizenship overlap. Some EU citizens may also belong to a minority in the host member state because of their race, color, ethnic or social origin, age or sexual orientation, to name just a few. Take the example of same-sex couples or transsexuals. When exercising their right to free movement, EU citizens who belong to those minorities run the risk of their civil status or gender identity not being recognized in the host member state, or even in the home member state, in a U-turn situation, like the recent case for Vodovoya Majowiecki, a Grand Chamber judgment of November 2025. I will come to that case law somewhat later for reasons of structuring of this presentation. But let me first go into the third building block, of which we already spoke a little bit at the end of the conference, solidarity. So rule of law, democracy, solidarity. The solidarity dimension of EU citizenship roots, of course, in the Schuman Declaration, where already reference was made to concrete achievements step by step in European integration, creating or based on, and at the same time based on, a factual solidarity, interdependence, vivre ensemble, miteinander, between the peoples and states in Europe. That is what the European society, of which Article 2 speaks, is all about. The principle of solidarity can be, or the value of solidarity, can be said to have been particularly influential in enriching the status of citizenship by creating links between individuals and the European Union, which are different from those which exist between individuals and their own member states. And that's, of course, very simple, because the non-nationals, as citizens of the Union, receive rights in the host member state of which they are not nationals. Simultaneously, it serves to highlight the importance of integration in the host member state. The more integrated an EU citizen is, the more solidary the society of the host member state becomes. In the context of social assistance benefits and maintenance aid for studies, engaging in economic activity serves as a trigger for solidarity to manifest fully, as the principle of equal treatment applies from day one. By contrast, regarding economically inactive EU citizens, the length of lawful residence based on EU law in the host member state is decisive. The more time an EU citizen has resided lawfully in the host member state, the more access he or she has to social assistance benefits. Notably, when adopting Directive 2004/38, the EU legislator introduced the status of permanent resident after 5 years. Where an EU citizen has lawfully resided in the host member state for a continuous period of 5 years, he or she completes his or her gradual integration. The 5-year mark is a political choice of the EU legislature. It's a democratic choice, which gives concrete expression to the value of democracy. It's a democratic choice which the courts have in principle to respect. But of course, subject to human dignity. And I know, unfortunately, I was absent because yesterday I was the whole day involved in the 7. Deutscher Arbeitsrechtstag here close by. So that's why I was absent. But I know you spoke about Dano. But I hope you also mentioned in that discussion the Department of Communities for Northern Ireland case, which is a crucially important case. It's a Grand Chamber judgment of 2021 or 22, I don't know by heart, where we said that the bottom line is human dignity. In other words, even in Dano cases where there is no equal treatment for the first 5 years, you can never deprive an EU citizen of what it takes to have a decent living. You cannot leave that person in extreme material need. And that is directly based on the Charter and on Article 1 of the Charter. It's one of the few examples where human dignity was mobilized in this solidarity context. So I draw the attention on it that you read this Dano Alimanovic line of case law together with Department of Communities for Northern Ireland, which is a serious, how you say that, corrective, but through another normative framework on the Dano Alimanovic line. And I think quite a number of academics have also seen that this way, in either a critical way or in an approving way, but that is very normal with every legal decision. That's not problematic in itself. So a permanent resident who is economically inactive may become an unreasonable burden on the social assistance system of the host member state, because the right of residence is so-called permanent and definitive. The difference between economically active and inactive EU citizens is, as I already said, highlighted by contrasting the ruling of the Court of Justice in Dano with that in chief appeals officers, it's still a more recent judgment, in the Dano case, the court held that an EU citizen can claim equal treatment with nationals of the host member state only if his residence in the territory of the host member state complies with the conditions laid down in Article 7.1b of Directive 2004/38. And as you all know, those conditions include the obligation of for an economically inactive EU citizen to have sufficient resources for himself and his family members and a full health coverage. By contrast, in Chief Appeals Officer and others, a judgment of 2023, the court held that the principle of equal treatment applies to a migrant worker in respect of his or her direct relatives in the ascending line who are dependent on him or her and claim social assistance benefits. Accordingly, if direct relatives in the ascending line who are dependent on workers who are nationals are entitled to those benefits, the same applies to the same category of relatives of migrant workers. So the divide between economically active and inactive EU citizens makes sense from the perspectives of the value of solidarity and equality. And this is because, just like a worker who is a national of the host member state, a migrant worker pays taxes and in so doing contributes to the financing of the social policies of that member state. It's the link between solidarity and responsibility. Those values therefore militate in favor of allowing such an EU citizen to profit from those policies under the same conditions as national workers. By contrast, an inactive EU citizen must forge a bond with the host member state before having access to social assistance benefits under the same conditions as nationals of that member state. Gradual integration by means of a lawful residence gives concrete expression to the value of solidarity, as it preserves the balance of rights and obligations that the member states have agreed upon on the basis of reciprocity. Furthermore, what enables the member states to trust each other and thus to show solidarity with each other's nationals is the sharing of a common code of fundamental values. The principle of mutual trust serves to draw the dividing line between the member states and third countries, since that principle only applies in full in relation to the member states. The case law on the extradition of EU citizens to third countries illustrates the point. In Petruhin, a Grand Chamber judgment of 2016, the court held that the fact that a member state may extradite EU citizens who are not its own nationals to a third state, while refusing to do so for its own nationals, constitutes unequal treatment which restricts those citizens' rights to free movement. The fight against impunity may constitute a legitimate objective justifying such unequal treatment. Still, before extraditing an EU citizen to a third state for the purposes of prosecution, the requested member state must inform the member state of which the EU citizen concerned is a national of that extradition request. That information affords the authorities of the member state of nationality of the person concerned, insofar as they have jurisdiction pursuant to their own national law, to prosecute that person for offences committed outside national territory, the opportunity to issue a European arrest warrant for the purposes of prosecution. So you see how it works. You have a bilateral agreement with a third country and you say, I won't extradite my own nationals. And now you have a national of another member state who lives on your territory. It's not covered by that exclusion with the third state. So you first ask the member state of nationality of that EU citizen, can you issue a European arrest warrant to have this person surrender to you so that you can decide to either prosecute or to hand over the person to the third state. So that is in fact the idea. So there is some protection for the EU citizen, somewhat similar to the protection of the national. That's the idea behind this Petruhin case. So it's a bit technical because it's extradition law, it's international criminal law, but I think it's a very strong example to show where our court already 10 years ago has given a substantive content to EU citizenship, extending what is protected through a nationality clause between a given state and a third country. So the rationale in Petruhin is imbued with the values of respect for the rule of law and solidarity. The rule of law is upheld, given that the principle of mutual trust, which underpins the system established by the European arrest warrant framework decision, ensures that the surrender of the EU citizen concerned to the member state of which he or she is a national will lead to criminal proceedings where fundamental rights are respected and where an independent and impartial court will rule without fear or favor. The value of solidarity is promoted insofar as the international obligations set out in the extradition treaty between the requested member state and the third state must accommodate the exercise of the rights attaching to the status of EU citizen. Because indeed, that's exactly what it is. This person, in Petruhin, it's an Estonian person who had used his free movement rights to Latvia. Latvia has an agreement with the third country. No Latvian nationals will be extradited, but we will try them themselves. So here is an Estonian. What to do? EU citizen. He's not the same protection, but a similar protection. So they ask Estonia. If Estonia asks the persons, then Estonia must make the choice to either try the person or surrender to the third country. So that this Estonian national is not being punished for having used his right of free movement. Because it's important to know that also Estonia had with the same third country such a clause not to surrender nationals. The fourth building block, the acquisition and loss of nationality. The building blocks of EU citizenship outlined so far are most clearly discernible when one examines more closely the rules governing the acquisition and loss of nationality. In that regard, the Court of Justice has consistently held that, I quote, while it is for each member state, having due regard to international law, to lay down the conditions for the grant and loss of the nationality of a member state, those powers must be exercised having due regard to EU law. That is already a quote from the 1992 judgment of the full court at that point in time, paragraph 10. So it's really a building block of the case law in relation to the grant and the loss of nationality, acquisition and loss of nationality. And of course that the powers must be exercised having due regard to EU law, that's of course a general quote. All national powers must be exercised having due regard to the general obligations flowing from EU law. That's pacta sunt servanda. That's pure public international law. You cannot conclude the treaty vis-à-vis 26 other member states and vis-à-vis the Union as a common legal person and say, oh, but I'm exercising my own competence. States are always exercising their own competence in public international law. But they must respect what they have promised to each other in the treaty. So that's purely Vienna Convention on the Law of Treaties. It's pacta sunt servanda. So, member state nationality is the gateway to EU citizenship. In order to become or remain an EU citizen, the person concerned must be a national of a member state. On the one hand, the acquisition of member state nationality means, notably in cases of naturalization, that the person concerned acquires new rights that are protected by effective remedies, that that person becomes part of the EU democratic process and may benefit from solidarity measures that relate to those rights. On the other hand, the loss of nationality means that the person concerned is deprived of his or her fundamental status of EU citizen and the rights attaching thereto. So let's first look into the case law, because it came chronologically first, to the loss of nationality. National measures that deprive an EU citizen of his or her nationality must pursue a legitimate objective and comply with the principle of proportionality. In Rothman, for example, 2010, Grand Chamber case, the court held that, I quote, "It is legitimate for a member state to wish to protect the special relationship of solidarity and good faith." So that's not newly invented, the Commission against Malta. It's a fixed line of solidarity and good faith between it, the state, and its nationals. And also the reciprocity of rights and duties which form the bedrock of the bond of nationality. That's paragraph 51 of Rothman, itself building further on a very old case. I say that for the researchers in the room, Commission against Belgium. You know, this first nationality thinking came under the provision of the old EEC treaty, which allowed member states to reserve to their own nationals certain public offices. And the court, our predecessors, 45 years ago, they restricted that to those public offices which entail exercise of sovereignty. But then they had to explain what nationality meant and why that could be the distinctive criterion, whereas normally it's the biggest red line in union law, no discrimination on grounds of nationality. So they had to explain the content of nationality as the kind of bond which could be required for certain aspects of the exercise of sovereignty, of sovereignty tasks of the member state, police, judges, and so on, right? And that's in fact where this case law, also Commission Malta, plunges its deep roots. And it shows how the court's jurisprudence works. Oftentimes you are faced with working out a problem in a particular area, substantive area of union law, and then you need to draw upon and to check whether that same philosophy applies or not as a general proposition of union law. And of course there is a strong presumption that it does, because it would be very strange that we see the bond of nationality between a person and the state, nation in this concept, differently in different aspects of union law. So, in order to protect that relationship of solidarity and good faith, the court continues in Rothman, a member state may withdraw from an EU citizen the nationality of that state acquired by naturalization when that nationality has been obtained by deception, on condition that the decision to withdraw observes the principle of proportionality. Why? The taking away of the nationality also means the taking away of union citizenship. You may even become stateless. So it's a very harsh consequence. So the negative consequences for the loss of the EU citizenship status and the rights attaching to that status, we spoke about status, rights, and identity, sense of belonging. Well, at least for the status and the rights, you lose it. Sense of belonging is maybe sociologically and psychologically more delicate. But I mean, status and rights, that's what we look at as lawyers in the first place, there is a clear impact. So the court said, in the light of that principle of proportionality, national authorities must take into account the consequences that the decision withdrawing naturalization entails for the person concerned, and if relevant for the members of his or her family, with regard to the loss of the rights enjoyed by every citizen of the Union. In the Thiebes case, some years later, 2019, the Grand Chamber of the Court further developed the Rothman line of case law, holding that it was legitimate for the Netherlands to deprive a Dutch national of his nationality if, after attaining his majority and while holding both the Dutch and the foreign nationality, so no risk of statelessness, he or she had his or her principal residence for an uninterrupted period of 10 years outside the EU, so in the third country. And that was because EU law does not oppose national legislation prescribing the loss of nationality in the absence of a, I quote, a genuine link between the member state concerned and its nationals. There the court uses the term genuine link because it was used by the Dutch legislation. And also that is important to note. We must, of course, stay in these cases because it's national law at the start and we have to check whether that is compatible with EU law. So we define the criterion as the national legislator has done it and we say, well, that's totally legitimate. Compliance with the principle of proportionality, of course, requires an individual examination of the consequences of that loss of nationality for the persons concerned from the point of view of EU law, that is, from the point of view of the loss of EU citizenship. Dutch authorities had to determine whether those consequences were consistent with the rights guaranteed in the Charter and specifically with the right to respect for family life enshrined in Article 7 of the Charter. This may sound a little bit abstract, but that is when these persons have then family members living in the EU. I save you the details, but this is what I mean by individual examination. And now we come, against that background drawn so far, to the point of the acquisition of nationality. In the Commission versus Malta judgment of April 2025, the question arose whether EU law may limit the conditions under which a person may, by naturalization, obtain the nationality of a member state and thus become an EU citizen. Malta had set up a special scheme for acquiring Maltese nationality by naturalization, which targeted investors requiring inter alia the applicant to pay a contribution of 600,000 euros or even 750,000 euros to the Maltese government. The Commission argued that this scheme amounted to is important, that's the court in a direct action, infringement procedure, the court must read and interpret and assess the national legislation. I stress the point because in academia it's often overlooked and people read an infringement judgment in the same way as a preliminary reference judgment or an annulment judgment like the conditionality cases. All these procedures are different frameworks within which the court says the law. So when we have an infringement action, we actually go deep into the national law, we make our own opinion of what it said, of course, after a contradictory debate, before us, between the Commission and the member state concerned, not only the law on the books, but also how it operates in practice, the whole context, factually and nationally, normatively, is assessed by the court. So the Commission here argued that the Maltese scheme amounted to, came to, if you want, commoditizing, that was the word used, in French, commercialiser, EU citizenship, which undermined the essence and integrity of that status and called into question the principle of mutual trust regarding decisions granting nationality adopted by the member states. In its defense, Malta sought to draw a distinction between the competences of the member states to withdraw nationality from those to grant nationality. In relation to the granting of nationality, Malta argued that EU law may only limit naturalization policies that amount in a general and systemic way to a serious breach of the values and objectives of the EU. And according to Malta, that was not the case with the 2020 scheme. In my view, three implications flow directly from the judgment of the Court of Justice in Commission against Malta, which reflect, in fact, the three building blocks of EU citizenship explored here. That is, rule of law, democracy, solidarity. First, the Court stressed the fact that nothing in the treaties justified subjecting national laws governing the conditions for granting nationality to only a limited review of their compatibility with EU law. Such a limited review would be contrary to the rule of law. Why is that so? Member states must simply comply with their general obligations flowing from union law. And these obligations imply respect for the values of Article 2 of the Charter and of the provisions of primary law, so that is in the framework of an infringement proceeding, a full review. So that is the rule of law aspect. The second, the Court of Justice interprets the treaty provisions on EU citizenship as being center stage in the process of democracy operating at the level of the European Union itself. The status of EU citizen is fundamental in the EU constitutional framework as it pushes integration further by promoting and protecting the values on which the EU is founded, values which define the very identity of the EU as a common legal order. Those are the values with which I started out, Article 2. European integration is not only shaped for the European citizens, but also by them. It's the European citizens that are the custodians of European integration, and that is the reason why naturalization policies must respect EU law and in particular the values of Article 2. The commercialization of EU citizenship would amount to buying one's way into the EU democratic process, which is fundamentally at odds with what democracy is all about. And indeed, this commercialization here, you read that in the judgment, I can't go in all the details, but here it was very clear that there was a commercialization scheme supported by advertising in the media and the social media, saying, pay in Malta and you have the free access to the whole European Union, and you can live everywhere, you can start a business everywhere, you can become a member of a political party. I just said it, Commission against Czech Republic, Commission against Poland. All of this is self-evident when you are acting in good faith. But of course, if you are an oligarch of a third country, and you can think of a few, and you have of course no difficulty paying in Malta, and then you come and establish your business in Germany, in France, in the Benelux, in the Scandinavian countries, which was not even an idea you needed to have yourself, by the way, because the program was publicized in that way, saying, buy your access, no further red tape bureaucracy. You pay in Malta, you benefit on the continent. So these are the facts. What you see, the links of solidarity and good faith, it's a very old strand in our case law, but which comes in a novel context. And I'm pleased to see, and that's another remark which I make here in an academic context, maybe also for further research. I'm very much struck that a case like this one, but not only this one, also others, they are then sort of discussed on competence. And what's the limit to competence? And that's fantastic. I know, that's the dogmatic theory, etc. But then you see that here in Germany, many of the colleagues, academic and otherwise, judicial, they say, wow, it's a fantastic judgment. This was fraud. This is bad faith. This cannot be. Fraus omnia corrumpit. And that's in a way what you read in the judgment. That's why we spoke about good faith. We couldn't say bad faith because the Commission had not used the word. It's a direct action, not ultra petita, but the reasoning is clear. So that is what I mean. So you always have to say member states are of course fully and only competent to grant or to withdraw their nationality. But they must do it in good faith, in an idea of solidarity, both with their own nationals and between the member states in an interactive and interdependent Europe. So the third implication is, within the EU legal order, the granting of nationality produces cross-border effects. As I said, that's now the academic version. By imposing a series of obligations on the member states where the EU citizen has exercised his or her rights attaching to that status. such an EU citizen is entitled to enter the labor market of that member state. He or she is protected against discriminatory measures falling within the scope of EU law. After gradual integration, like already said, the citizen may receive solidarity-based support from the host member state society. In order for the host member state to accept those obligations, the member state of naturalization cannot treat the ground of nationality as a business, since that would be free riding on the opportunities offered by other member states. And that is the deep strand of Commission against Malta. It would tilt the balance between those two member states, the host member state and the naturalization granting member state. That is the reason why EU law requires the grant of nationality to be based on a truly existing special relationship of solidarity and good faith between the member state granting naturalization and its nationals. And of course, the court is not proactively defining all the variants, factually speaking. No, this is an infringement action. We are dealing with this very scheme, and it didn't pass the test. That does not mean that there cannot be a full array. And in many conferences I hear say, and would that pass, and would that pass? Well, it's nice speculation, probably it will pass. But if you come to an extreme case like this one, it will not pass. So that's how you should read the judgment. Finally, as I said, after these different blocks of rule of law, democracy, solidarity, and citizenship as such, how the Court of Justice really works, the stone-by-stone approach. The Court of Justice operates under the principle of collegiality. Yeah, we don't have dissenting opinions, not because we decided not to have them, because the member states, as Herren der Verträge, decided that we may not have them. This is in the protocol attached to the treaties, protocol on the status of the Court of Justice. So all of that means that reaching an outcome based on a consensus is of paramount importance for the daily inner workings of the court. And when I say consensus, I mean, it's somewhat difficult because it's really my task as president to make it happen, to bring these people together and to combine the talents around the table. It's a fantastic process. Huh? And everyone gives the best of her or himself. And so we really forge a common reasoning which can be persuasive. It's Hamilton saying, the judiciary is the least dangerous branch. We don't have the power of the sword, nor the power of the purse. We only have the power of persuasion. And we stand to be criticized, because the harsher and the sharper the criticism, the better we can refocus our persuasive force. That's the interaction between science, scholarship, and the bench. I'm a pupil of Stephen Breyer, the former justice of the American Supreme Court, professor at Harvard Law School at the end of the 70s and the beginning of the 80s, I'm afraid to say, of the past century. And he said already then, the young students we were, the law develops in the triangle between the bar, the bench, and the classroom. Because in the US system, the scholarship of the professors is tested in the classroom, which is an interactive process, the so-called Socratic method. And it's really that process which also works through in the court's approach, stone by stone, step by step development of the case law. So for the sake of consensus, in hard cases, the discourse of the court cannot be as profuse as it might be. An advocate general can be slightly broader because that's a single opinion and it's an opinion. So that is something you should always see. And then, as I already said, you have to see the type of procedure which is at hand. And guard yourself to read the judgment like you would read a statutory provision. It's not a normative act. And what is totally dangerous, I would say in rules of academic ethics, it would almost be an ethical offense, that is to take a paragraph from a judgment and to quote it out of context, like though it were a statement, autonomously to be taken as such. Any paragraph must always be related to the whole judgment in which it occurs, and if it's a direct action, cut down to the facts of the case. So as consensus building requires bringing on board as many standpoints, arguments, reasonings possible, the argumentative discourse of the Court of Justice is limited to the very essential. In order to preserve consensus, the Court does not take long jumps when expounding the rationale underpinning the solution given to novel questions of constitutional importance. Because if you decide in an overbroad fashion, you risk to regret it in another case where it is more properly argued. You must, of course, not be under-inclusive either. You must give sufficient argument to support the outcome of the case. So the persuasiveness of the argumentative discourse is built up progressively, case by case. There is a very famous article in the Harvard Law Review by our academic colleague Cass Sunstein. If you didn't read it yet, you must. One case at a time. That's the title of the article. And it explains very well how the Supreme Court in the United States, but also other federal judges there, and he also makes some comparative leaps, go case by case and build up the case law and the distinction between case law and what a legislator or an executive might do. I would briefly like to illustrate this approach by referring back to the Koen case law, already alluded to somewhat earlier. Regarding the mobility of same-sex couples, the Court of Justice was called upon to interpret the term spouse within the meaning of Directive 2004/38 in the famous Koen case of June 18. By the way, why did we have to interpret the word spouse? That's also interesting. If you take the directive, it is defined with very great precision all which categories of children are family members, and the registered partner, and according to the law of which member state that registration needs to be valid. So almost a private international law collisions norm. But here, just a spouse. Actually, when you go look in the travaux préparatoires, preparatory works of the directive, you find that the directive was in fact delayed for almost a year because of the spouse. They could not agree to define it. The same-sex couples problem you have, of course, understood. They could not even agree in accordance with the law of which member state that was to be decided. So in the end, they say, this is as good as it gets. We simply say spouse. And if that ever gives rise to problems, everyone knew that it would, that will be for the Court of Justice to decide. I say that because it relativizes the judicial activism claim, right? This is what we call constructive ambiguity, in deliberately so, in a negotiated process of legislation, within the Council to find a qualified majority, 55% of the states representing at least 65% of the population, and parliamentary majority in the European Parliament, and the two have to agree to the comma precise on the same text, the trilogues, or more formally the conciliation committee, if it really is difficult. Okay. So you get texts which are less qualitative, less explained than you might have in national legislation. And it happens all the time. And when it's to decide what is immovable property for the purposes of the VAT directive, except some tax lawyers, no one is very much moved by the problem. But when it's defining the spouse, and it puts on the table the whole question of same-sex marriage to be recognized or not, in some of our member states, this still stirs up all the public opinion. So that is very often the situation in which the code finds itself, with huge differences in the prise de parole of the member states, in the standpoints of the member states. So, as you know, this case concerns a Romanian national, Mr. Koen, and an American national, Mr. Hamilton. And the two insisted that their names be used, because they have also on the internet a page where they have documented their whole ordeal. Koen is a migrant worker in Belgium. There he meets Mr. Hamilton, they live there together, and they get married in Belgium. In Belgium, private international law says, as a connecting factor, the habitual residence of the spouses. Belgian law knows the same-sex marriage, so they're married in Brussels. Now, after a number of years, important number of years as a couple in Belgium, Mr. Koen returns with Mr. Hamilton to Romania, his home state. There, Mr. Hamilton applies to be recognized as the spouse of an EU citizen, as a family member under the directive which was only applicable by analogy, because it was, of course, not invocable by Mr. Koen, since he was a national of the Romanian defendant state. But, I mean, that's technicality. But we had, of course, to interpret the directive and the notion of spouse. Both the Advocate General, Melchior Wathelet, and the Court of Justice concurred in that the term spouse within the meaning of the directive is gender neutral and thus may include a spouse of the same sex of the EU citizen concerned. The Advocate General noted that there was no consensus between the member states on a traditional definition of marriage. Since then, back in time, few more in the meantime, 15 member states allowed marriage of persons of the same sex, while the rest, including Romania, did not. Such a lack of consensus logically implies that the term spouse had to be interpreted in a neutral manner. What's preventing the member states from imposing unjustified restrictions on the rights of free movement of the EU citizens concerned and on their right to respect for private and family life enshrined in Article 7 of the Charter. All of this meant, in essence, that it is for the member state in which a marriage is celebrated to decide whether same-sex couples are allowed to get married. So you see, it is for the member state. So we supplied the private international law rule in the conflict of laws between two member states. If that is the case, in this case Belgium, another member state, in this case Romania, cannot rely on its national law to oppose recognition in its territory for the purpose of granting a derived right of residence to the third country national of a marriage concluded by that national with a union citizen of the same sex in another member state in accordance with the law of that state. So, frankly speaking, Romania was to grant a residence permanent to US national Mr. Koen as the spouse of Mr. Koen, to Hamilton, spouse Mr. Koen. Interesting is here to compare this to the United States Supreme Court. That's my academic field, as you know, of comparative constitutional law, especially with the United States, with the 2015 judgment, Obergefell. In Obergefell, it's very easy, Belgium is Maryland, okay? Romania is Ohio. So the two, same-sex couple, are married in Maryland, where family law is state law, like in Europe. They go to Ohio and they say Ohio law, Ohio family law does not recognize the same-sex marriage. The case goes all the way up to the Supreme Court. And there the Supreme Court obliges Ohio to recognize the marriage lawfully concluded in Maryland under the US full faith and credit clause, which is an express clause containing the same substance as our principle of mutual recognition. That's what it is. which is by us partly in legislation, EU legislation, and partly in court case law, under primary law. So far, strict parallel. But what happens then? And then it becomes interesting. The US Supreme Court in Obergefell said, because that had been argued by Ohio in defense, they said, we can't be obliged under the full faith and credit clause to recognize that marriage from Maryland, because if we are so obliged, it will in fact mean that there are two categories of same-sex couples in Ohio. Those who have made use of their right of free movement to another state of the United States and been lawfully married there, they come back, they're also married in Ohio. And same-sex couples which make their life, we would say static citizens, in Ohio, they cannot get so married. So that was a defense argument for from Ohio in order not to have to recognize. First of all, 5 against 4, the Supreme Court did not take that argument and said, no, the full faith and credit clause is sort of binding and must be complied with. But then, answering to that argument, it led to what we would call in soccer an own goal for Ohio. They said, and by the way, as far as your argument is concerned about the unequal treatment, you're right. But it does not entail to the consequence that we should refuse full faith and credit. It should lead to the fully opposite consequence, that you are obliged to introduce same-sex marriage also in Ohio, and by extension in all 50 states. That second step, needless to say, the Court of Justice of the European Union, and I can tell you in 2018 we were absolutely aware of Obergefell, which was by my par mes soins available for all the judges, in order to make the distinction. We did, of course, not take the second step, because that would have been ultra vires, Prinzip der Einzelermächtigung, conferral of competence, family law is national law. We say if there are problems of equal treatment, that is for the Romanian legal order to solve that. In its legislation, in its case law of the Constitutional Court, or through whatever constitutional means available as a matter of domestic law. So very deliberately, we did not take the second step. Stone by stone, we construe very differently. And that way, we also said that there was no problem of respect for national identity, because they could make their own choice, but we said, you may make your own choice, but it implies that that you should also respect the different choice made in all the other member states. So it's again this matter of interdependence of member states in a big area without control at the internal frontiers. That's relevant. It's a big free movement area. You should take people with the lawful family status they have acquired lawfully in a member state where they first acquired it. And with that status, you go through the whole area. But every member state is equally entitled to make its own choices, respecting the equal freedom of the other member states to make their choices. And that, of course, comes through in the next case law. We had it in the Pancharevo case, where we had a lesbian couple married in Spain. They have together a child, the two ladies, and under Spanish law, it may not be revealed, when the ladies so wish, who is the mother of the child and who is the co-mother. The two mothers are on equal footing when they so wish, so there is no taken legal notice of who actually gave birth to the child. When they return to Bulgaria, one of the ladies being Bulgarian, the Bulgarian said, all you want, but I need to know who is the biological mother of that child, because otherwise I can't determine whether it is the Bulgarian lady or the British lady, the other mother. So that won't work. The ladies refused to give the identity of the lady who had given birth to the child, which is totally valid under Spanish law. And the court said that's their right to do so. The Bulgarian authorities have to sort of issue the travel documents for the two ladies on the basis of the Spanish birth certificate to the two ladies so that the two ladies can travel with the child. So you see there again, we don't say that Bulgaria is to recognize them, the two of them, as the mothers. That is not the issue of union law. Again, principle of limited competence. It's to make free movement possible. And that is here what we decided. Now, you have, of course, read also our most recent Vojevoda Mazowiecki case, which is in fact a further illustration. But before coming into that, I would like to emphasize that the court considered in this Pancharevo case, and that is worth mentioning, that it would be contrary to the fundamental rights enshrined in Article 7 and 24 of the Charter to deprive the child, that's the Pancharevo case, of the relationship with one of his parents in the exercise of his right to free movement, or to make the exercise of that right de facto impossible or excessively difficult on the grounds that his parents are of the same sex. In another key passage of the judgment, the court adds, the obligation to issue a passport or identity card, for the child that is, does not require the member state of which the child concerned is a national to provide in its national law same-sex parenthood or to recognize for the purposes other than the exercise of the rights that the child derives from EU law, the filiation link between the child and the persons mentioned as being the child's parents in the birth certificate issued by authorities of the host member state. So here again, just like in the Koen case, we didn't oblige Romania to introduce same-sex marriage, we did not oblige Bulgaria here to recognize this child as being the child of the two ladies on an equal footing for the purposes of family law, inheritance law, or what have you. And the only thing which was submitted to us so far, because you need a substantive law nexus to union law, was the free movement law. In the Mirin case, 2024, Grand Chamber judgment, where exceptionally, because a colleague had sadly died, I was the president and the reporting judge, the Court of Justice continued to develop the Koen case law while adapting it to transgender persons and emphasizing the importance of protecting gender identity in the EU legal order. The court ruled that when an EU citizen legally changes their first name and gender identity in the host member state, where they exercise their right to free movement, in this case the United Kingdom before Brexit, the member state of origin, in this case again Romania, must recognize that change unless it can invoke compelling reasons for not doing so. This is because having different first name and gender identity may bring about serious inconvenience to the EU citizens concerned at administrative, professional, and private levels. So here again, you see that the court remains within the confines of substantive union law. It is applying the substantive union law in combination with the charter rights, Article 7, Article 24, depending on the case. And it is, of course, enormously enriched in its thinking by the case law of the European Court of Human Rights, which in all these cases is extensively quoted on the basis of the passerelle clause of Article 52, third paragraph of the Charter, that the rights need to be at least so interpreted and applied that they guarantee an equal protection. And that's very important. So I think this convergence between European Court of Justice, the Court of Justice of the European Union, and European Court of Human Rights case law will become increasingly relevant in the coming periods, because we have more and more cases where you're far away from the market thinking, but you're simply dealing with citizens in any case of law, family law, criminal law, migration law, that is human context where the human rights are absolutely center stage. Lastly, in the quoted Vojevoda Mazowiecki judgment, the court referred to the case law on serious inconvenience, which I just quoted, developed in the Miring judgment, and applied it by analogy to the free movement of same-sex couples. The court reiterated the need to protect the right to privacy of same-sex couples while respecting the national identity of the member state concerned. The court thus ruled that the member state has an obligation to recognize the marriage of two citizens of the union of the same sex legally concluded in another member state where they have exercised their freedom of movement and residence, since such a refusal is liable to cause serious inconvenience for those citizens at administrative, professional and private levels. Stone by stone. Koen was a Romanian with a US national, under the directive by analogy. Then you have here, you'd say, well, what's different with Koen? Well, the context. It's two Polish men who live and work in Germany. They marry here, but two Polish men, and they go back to Poland. Obviously here, the question arose, is this genuine? The answer in this case was yes, because there were many years in Germany, so it was established. But, you know, there are borderline cases. So step by step. And then the Polish authorities could only recognize the marriage through a change of the civil registers. That was also a problem. So we said, well, you need not to do that. You may also use another way of giving recognition. That's your choice. If you say it's the only way to recognize the same-sex marriage concluded in Germany between these two Polish men who returned to their home state, then of course you, if you have no other means, then you have to change the civil register. Step by step. And we always see what the reactions are. And in many of these cases, it will not escape you, there is a huge discrepancy as to the reaction in the different member states. In all the member states knowing same-sex marriage or a registered partnership which comes close to it, Lebenspartnerschaft or so, that's close enough, they praise the judgments. They might even criticize it for not going far enough. That is, for not having put the second step à la Obergefell against Ohio, which we won't, because that would be plainly against the principle of conferral. But that is really what it is. Now, in other member states, it goes way too far. And they say, well, this connection with free movement is in fact a very weak connecting factor to EU law, substantive EU law, and it's a way of getting through the back door. That is why in all this case law, we are so intensely referring to the case law of the Human Rights Court. It gives us an additional support, but a crucial one, because we say to these member states, and these cases are delivered against Poland, against Romania, against these states, basically we tell them, yes, but you have to comply anyway with this Strasbourg case law. So what we are saying in our case law is en deçà. It's lower than what you have to do anyway under the Strasbourg case law. It's a very beautiful way of convergence between the two courts, and it's rather deliberate. It's a genius of Article 52, paragraph 3, and Article 53 of the Charter. I conclude. In order to fully deliver on the promise to become the fundamental status of nationals of the member states, EU citizenship must serve to protect and promote the values on which the EU is founded. EU citizenship is an essential component of the identity of the European Union as a common legal order that guarantees that the European integration project moves forward in accordance with the 12 values which I enumerated of Article 2. EU citizenship confers rights on nationals of the member states that must be protected by independent and strong courts. It opens the door to political participation and engagement in a democratic system at the different levels of democracy, national and EU. Whilst free and fair elections are essential for a democracy, that value requires much more. No tyranny of the majority. That is why the Court of Justice has interpreted EU law in a way that strengthens the value of democracy. EU citizenship entails that member states help each other in attaining common objectives by allocating responsibilities, respecting commitments, and acting on the basis of reciprocity. The value of solidarity underpins the status of EU citizen, since it serves to find and preserve the balance of the rights and obligations that the member states, as masters of the treaties, agreed upon. In further shaping EU citizenship, it is worth emphasizing that the Court of Justice acknowledges both the need to consider the degree of consensus among the member states and the importance of safeguarding national identity, since EU citizenship is intrinsically linked to member state nationality as it is derived exclusively from that nationality. Thank you very much.
Thank you so much, President Lenaerts, for your speech. You see there's a large audience. It's made for the Humboldt students, first of all. So we have still some time for some questions, so please raise your hands if you have a question to the President of the European Court of Justice. Nobody dares to? I cannot believe that. There's a question from a student in the second row there. I start with the students and then with the students, the advanced students come later.
Yeah, first of all, thank you for your presentation, which was very insightful. And I want to start with a point you made because you quoted from the Federalist Papers number 78 from Hamilton. And he, of course, said that the judiciary was the weakest branch of government. And this can be a benefit for the court internally because it has to rely on the power of persuasion. But when it comes to the external relations the court has with other branches of government, it's, of course, an enormous weakness. And you talked about the significance of the independence of the courts on a national level. But then in Europe, currently we have a situation that we have governments which become ever more detached from their commitment to the principle of the rule of law. And there was, for example, an analysis from 2015 to 19, which looked at how the verdicts of a court were actually implemented on the national level. And the result was that still in the majority of cases, the verdict was fully implemented, but then there was 10% of cases where the verdicts were not implemented at all, and then there was an additional roughly 20% where it was only implemented partially. So you have the court making verdicts, which it can't enforce itself, it relies on the member states for that, and in 1/3 of cases, that's not fully realized. And then, of course, you also have the problem of some national courts, for example, who question the wisdom of a court. For example, our own German National Constitutional Court, which in the case of a public sector purchase program of the ECB said, or at least questioned, the last resort function of a court to have the last say. And so in this framework, I want to ask you, what do you see as the most danger to the court's legitimacy or the court's standing on the European level? And do you see an erosion of its effectiveness?
Well, those are, of course, several questions in one, so to speak. But but it's perfect question. I think the legitimacy of the court, to take that word, entirely depends on the transparency and the quality of the judicial debate in front of the court and the interaction of the judicial decision with the sort of arguments put forward in that debate. So I see legitimacy as the force of persuasion, and a court must persuade the party that loses. The party that wins has hardly the need of a reasoning. It's somewhat playful what I'm now saying, but if one of our grandchildren, I'm at that stage and they're still small, they ask for a piece of chocolate, I'm a Belgian, so I must take that example, and I say yes, then they take the chocolate and they run away. You don't have to reason anything. If I say no, then the question is, why? And they're only 5 years old. Then you have to explain. So the legitimacy of the court's process is to convince the parties that maybe at one or another angle, under one or another angle, dissatisfied with the outcome of the case. That's why you need to take very seriously the arguments which you dismiss, and do that openly, transparently, not put an argument sort of under den Teppich, sort of to push it, to brush it aside in order not to have to meet it. The question you raise about judgments not being implemented is a totally different one. Indeed, I refer to Hamilton's Federalist number 78, it's in my footnote effectively, because this is of all times in a system of separation of powers that courts cannot enforce compliance with their own judgments. It always depends on the legislature and or the executive, also at national level, to comply with it, to draw the consequences. And the rule of law, existential sort of feature of a state, can be measured on the basis of the compliance with the judgments. For our court, it is indeed for the member states and for the European Commission to oversee compliance with the judgments. Both the Commission and the member states can bring infringement actions for non-compliance with judgments. And even more so, and it really happens much more than you would think, the financial sanctions which are imposed for non-compliance with the judgments, and they really cut deep. That is the member states themselves which, through successive treaty amendments, have completed or supplemented Article 260 of the TFEU with paragraphs, especially paragraph 2, but also paragraph 3, even from the first time onwards, for non-compliance with EU law. But the paragraph 2 is non-compliance with judgments of the Court of Justice, which can lead to lump sums and to periodic penalty payments. The periodic penalty payments are there to force, it's an astreinte, zwangsgeld, to force the member state to comply as quickly as possible. But even if the member state complies during the proceedings, there still may be a lump sum for the delay which it took of compliance within a reasonable time with the judgment. And of course, when it comes to non-implementation of directives, that's crucial because 2/3, if not more, of union legislation is adopted in the form of directives. There can already be a financial sanction requested by the Commission. The Commission does lump sum and or periodic penalty payment for non-compliance within the time limit set of the directive. So it all shows that in the EU legal order, like in the United States, like in Germany, like in Belgium, like in any of the states I know, it's always incumbent upon the executive and or the legislature to comply. And there is, of course, quite a bit of pressure. There is also the conditionality regime. I mean, it would lead me too far, but there are many compliance sort of forcing mechanisms. Are they perfect? Are they fully leading to the results which we would wish? The answer is definitely no. But it's much more than a classical international organization. Do not forget that we come from Van Gent en Loos and Costa INL, which had to be jurisprudentially established and so on. And then the court, like Eric Stein once said, was tucked away in benign neglect on the plateau of Kirchberg, for 30 years than it was when it was a common market court. But from the Single European Act, when it became an area without internal frontiers, triggering therefore the common character of policies which are highly sensitive politically, such as migration, asylum, judicial cooperation in criminal matters, and so many other politically sensitive sensitive policies in the common area, then the member states suddenly get confronted with requirements of union law, which sometimes they only really discover after a judgment of our court. And then they are surprised, and it may take some more time. But you know that Hungary has been condemned to pay 200 million euros by way of lump sum and a daily periodic penalty payment, a daily of 1 million, for non-compliance with the judgments in the framework of the common asylum policy. And don't think that they might decide not to pay, because it's simply withheld at source from anything due by the Union to Hungary. So it is really more effective than you think. But if you ask me, are there cases of non-compliance? Of course. But are there cases of non-compliance in our member states with the national judiciary's decisions? The answer is unfortunately also. We have had one case, a reference from the Appeals Administrative Court from Munich, Bavaria, Freistaat Bayern. And the question was, kunnen wir Markus Söder in Zwangshaft nemen? Huh? Can we take him in prison? Because he is not complying, not with our judgment, with the judgment of this administrative court in Bavaria, implementing the preliminary ruling which we had given on request of that judgment, which they had faithfully applied, and spelled out the obligations in order to reach air quality standards in an environmental case. And then he didn't do anything. He even publicly declared that he would not follow the judgment. And the judges were so appalled, they got seized afresh of the case, and they came back to us. And they said, can we now put him in prison? Well, we said not so quick, but there should indeed be enforced. So to tell you, this is a phenomenon that exists in Germany, in Belgium, unfortunately, with the overpopulation of prisons, judges convicting the state, and something happening, but far too little. Yes, it's the least dangerous, but also the weakest branch. But we have the power of the law and the persuasion, and we must go on putting out a compass to which then also the electorate can hold the people to comply with the line of the law.
Thank you so much also for the interesting case that many of the students that hadn't heard about
Deutsche Umwelthilfe 2019.
Received it with some fun. Okay, other question. There's a lady on this side of the... You must take a microphone.
Thank you so much. I study law here at the HU, and a few weeks ago we had a judge from the German Federal Court of Justice with us. Mm-hmm. And there we asked her how she feels about the rise of far right and the changing political climate. And she said that if there ever comes a point where she feels that the law and justice, the gap becomes too big, that she would then not only leave her office, but probably also leave the country. Mm-hmm. And I was thinking quite a lot about that also now in the US, prosecutors quitting, also judges quitting, that of course when the good ones are leaving, who then is left? So I would be curious about your take if there ever comes a situation where if you're part of the judiciary, your own personal integrity could be affected.
Yeah, thank you very much for this excellent question. First of all, I have been in the Bundesgerichtshof for their 75th anniversary, and I've even written in their Festschrift for the 75th anniversary. So I really want here publicly to pay tribute to the Bundesgerichtshof, which is one of our best partners and interlocutors for the development and the Rechtsfortbildung of union law. So that's a very good cooperation. But I would personally not be in that in that reaction, so to speak. I think that we should go on till the last man standing. But of course, we have maybe a slightly better position because of what I've said in the speech, this collegiate character of our decision-making. It was, in my view, even though academics regret it, one of the wisest decisions of the member states as Herren der Verträge to say that every decision of the Court of Justice needs to be collegiate and in the end decided by everyone. When we take our oath of office, we promise three things, basically. First of all, to do our best. That's what you ask from children in primary school, so that's place for itself. You should do your best. You should be independent. And the third is, you should respect the secrecy of the deliberation during your mandate at any point in time thereafter. And that protects the individual judge. If you see what Trump did with some of the colleagues of the International Criminal Court, they're more personally focused in taking some of the decisions, he kicks at them. Now, the same American president has also taken on our court. When we ruled on the state aid case relating to Apple and the taxes it was due to pay in Ireland, which with interests included amounted to 16 billion euros to be paid to Ireland, not to the European Union, because this was an unlawful state aid in the form of a tax break, of a selective tax break. I'm summarizing the case. Trump came in immediately and said that the court had imposed a fine on Apple to finance the budget of the European Union. But we are a college. No, I mean, I have this in my souvenirs, so it's... but this won't impress us. The law must be set without fear or favor. So it's not an empty saying. Of course, there can be, pressure, which indirectly say, well, if you continue to be as harsh, by the way, that's of course, in the first place, the union legislator. Think about GDPR, think about state aid rules, already mentioned, but also the DSA, Digital Services Act, the Digital Market Act, now the newly adopted instrument against disinformation and hate speech, etc. It's in the first place a legislative thing. We might be called upon to check compliance with primary law. We have then to interpret and enforce it. That's quite clear. So yes, there is of course in general political speech that diffuse pressure in the sense of criticism, whatever, but it doesn't go any further. And we are protected by our collegiate system, secrecy of deliberation, and the fact that the judges play, in fact, almost an anonymous role. It's the court speaking. We are not like in the United States. There you can see the 9 justices of the Supreme Court on television platforms and taking part in podium discussion. So that's all unknown with us. And that insulates us. I think it also insulates the Bundesgerichtshof, to be frank with you, because it's also a collegiate way of working. But yes, I think we must hold out there and certainly not be sort of scared away.
Thank you. Another student questions in the very back. You may use... Yes, please stand up.
Hello. The court has stated in many cases and also in Commission v. Malta that I think the wording is that European citizenship is the primary status of European citizens, and critics say that that reference is illogical since, as you have also said, European citizenship derives from national citizenship. I think that sentence is misunderstood since it also, since in the case law going back, it serves the purpose of, I think, reiterating Article 18 TFEU, but I wanted to ask you, what does the court mean with this sentence, and do you think it is being misunderstood?
Thank you very much. Excellent question. In fact, this quote, it's not, and you will forgive me that I'm correcting it, but it's important. The quote does not say the primary status, because there you're absolutely right. It is not. If it's primary, it would be the nationality. The quote says that EU citizenship is the fundamental status of the citizens of the Union when they move around through the whole area, the Schengen area, without internal frontiers, so to speak. In other words, it is clearly thought in a free movement context. And I say this because this quote was developed way before I was even a member of the court, and I'm in my 23rd year at the Court of Justice, not counting my years in the General Court. So to tell you, it's a very old formula. And some academics, like our friend Joseph Weiler, in the last FIDE Congress, he discovered that and he said, oh, it's all wrong. But in fact, this is not new. In the Commission against Malta case, I told him that, so I can repeat it here. This is a repetition of what the court had said 25 years earlier. In the Martinez Sala case, but especially developed with that quote, there were the first sort of, in other wording, signs in the Martinez Sala case 1998. But then full-blown in the Grzelczyk case, it's difficult to pronounce, it's a Polish case, was a Polish, even before the accession of Poland, it's a 2001 case, but this was a Pole who lived in France and had naturalized French and then came to Belgium. So that's where the court said it. And it was about a student who was in his last year of university training at Louvain-la-Neuve in Belgium, and he needed the help of the Minimex, the minimum income, because he had no means of subsistence. And the court set in on equal treatment and said this is the fundamental status of nationals of a member state in all the other member states. That's where it comes from. And so we use that same here with the same perspective as I was explaining in the case. We say, in fact, Malta is selling its nationality in order to have them enjoy that fundamental status of EU citizen in all the other member states, as I was explaining. So it strictly frames with the same cross-border dimension, and it also goes back to what you very well know, the opinion of Advocate General Jacobs in 1993, Civis Europaeus Sum, where he explains that you have all the rights attaching to your being a national of a member state, and he said this in an opinion of 93, just after the conclusion of the Maastricht Treaty. So even before Martinez Sala, 98, and Grzelczyk 2001. So just to tell you, that is how it should be seen. There's nothing more to it.
Thank you so much. There were further questions. Please, the gentleman here.
Thank you very much for your speech. My question also concerns the General Attorney Jacobs you mentioned, concerning the Article 263 procedure. I wonder why, or what is the interest of the court to set the threshold for the individual procedure so high? Because we saw, or you talked about all the other cases where the court has a rather progressive interpretation, and then in this case it's more restrictive. So I'm just wondering, what is the interest in that?
Well, I'm extremely pleased with that question. That means more than happy, because I'm here in an academic context, and I'll tell here what I've been saying the last 25 years to my students in Leuven. In matters of Article 263, paragraph 4, I'm still a judge of the General Court. I don't know whether you seize the point, but I have drafted the Jégo-Quéré judgment of the General Court in 2002. And I may say that because that's on public record. Now, I told my colleagues, 5 judges, that's not secrecy of deliberation, it's after the judgment, judgment was delivered, I said, well, now I have to warn you, this judgment will be annulled because it's contrary to Plowman. But we must do it because in 2002, the Convention on the Future of Europe was on with a view to the Constitutional Treaty, which in that form and as such failed. But thanks to Chancellor Angela Merkel, it's really her credit, her merit. It was relaunched under the German presidency of the first part of 2007 and resulted for 90% identical in the Lisbon Treaty. So the General Court then said, the Court of Justice will not move. That was clear when they had not followed Advocate General Jacobs in the Unión de Pequeños Agricultores case. So we said we are going to point out why there is a problem with the Plowman test in specific cases, when you have a rule of a general scope of application which imposes directly obligations on economic operators or takes away rights from them. That's the two categories we set. Then Plowman says, yes, but what distinguishes you with so many others? So if you're very many to suffer from additional obligations or from the taking away of rights, you're done. You're not admissible. So we explained very finely that this cannot be the case. We had only one audience in mind, the Convention on the Future of Europe. So when the judgment was delivered, it was immediately sent to the Presidium, that's in public record, and they started working on it. So the new version of Article 263, fourth paragraph, is a direct transposition of Gégaud-Quéré, of the Tribunal, because Gégaud-Quéré related to a commission decision of general scope of application on the size of the mazes in the fishing nets. They had to be bigger so that less fish be caught and the biological diversity of the fishing stocks be ensured. But of course, the fisher people who lived from that, they said, now we are deficitaire, we can't survive. So we directly touched. So the Court of Justice said, on appeal, quashing our judgment, no. The Convention said, well, this is an executive rule of general scope of application. That should be reviewable. And that is the last sentence of the present paragraph 4, regulatory acts of direct concern and which don't need further implementing in the national legal orders, because effectively it's the act itself which directly takes away rights or grants obligations. And then the next point is, why not for legislative acts? We had formulated in the Gégaud-Quéré case, in the framework of that case, and that it was there an executive act, because the basic legislative act was a council regulation. In the convention, there were long talks about the extension or not to legislative acts. But the member states, and it's maybe somewhat surprising for a largely German audience, there are many member states in which, even at national level, there is no constitutional review of legislation of the parliament. It was, of course, strongly the case in the United Kingdom at that time, and in the Netherlands, and in a few other member states. So that was a bridge too far. So they did not agree to extend this direct concern without individual concern, when there were no implementing acts, when it was a legislative act, which Lisbon Treaty clearly identifies, ordinary legislative procedure or special legislative procedure, they said, no, that has a higher degree of democratic legitimacy, European Parliament and the Council, etc. So that is not reviewable. There, the Plowman standard remains. But for the executive acts, that means delegated acts or implementing acts, to use the terminology in English of Articles 290 and 291 TFEU, they are now, when they're of direct concern and they impose directly obligations or take away rights, they are reviewable. So it's sort of a middle road solution. And the court squashing of Gégaud-Quéré is become without object, because the new version of Article 263, paragraph 4, is totally covered by Jégo-Quéré of the General Court, not by Jégo-Quéré of the Court of Justice. And when they quashed the judgment of 2002 of the General Court, I had in the meantime been promoted to the Court of Justice. So actually, I was not sitting, of course, but I saw my colleagues annul it, and thereafter I was vindicated in 2009 with the entry into force of the Lisbon Treaty. So it's a subtle example of interaction between the judicial process and the political process. That's also, I think, an interesting dimension in the sort of triangle of values we discuss, rule of law, democracy, and human rights.
Thank you so much. One last question from in the room. Is there any?
Think,
oh, yes. Please go ahead. Yes.
Right. Thank you so much for coming here and speaking to us. I have a question regarding technical sovereignty. You said you were ready to take on Trump. I recently was in a class, or the Court of Justice, with the Verfassungsblock, and they mentioned that Germany's justice system would crumble in an instant if for example, the anti-coercion instrument of the EU was used.
Which instrument?
The anti-coercion instrument regarding Greenland. Parts of it would ban American tech companies. And yeah, I mean, the Court of Justice is a way bigger target of Trump than the German judicial system. So I was wondering how dependent are we, and could the court function without Office 365?
Well, it's of course largely in the political realm that your question situates itself, but it is true that the Court of Justice is a totally self-managed institution. There is no EU Ministry of Justice, like the Bundesministerium der Justiz, where I was yesterday evening for the Neujahrsempfang. We don't have such an impressive machinery to organize the judiciary. So the Court of Justice is self-managed. And I can say that we watch out very clearly in terms of cybersecurity and technological independence, what is being done and needs to be done further. So that is absolutely in the purview of what we're dealing with. But with this bazooka and the coercion instrument, of course, we have not yet been confronted, fortunately enough. And I think all these weighing ups, where the court, of course, is not involved, because it's the political institutions, have to come first. But fortunately enough, it has not been necessary, at least not so far. But it's of course that we are not sleeping as the ultimate responsible person for the management of the institution, which is a big institution. It's 2,500 people, all working with, of course, digital instruments. It is a real aspect, and we are fully involved in taking the necessary decisions. We have now decided since, and that's very important, since very recently, to equip all the work posts of the 2,500 people with the DeepL Pro, the best version of DeepL, which is a paying version, and that is, as you know, German, it's European, and it has its own cloud. That is a major step, and we work further on that direction. But that's how far I can go in the public.
Thank you very much. Now, for those who couldn't ask a question now, President Lenaerts will not leave us.
No, I'm still here.
Afterwards, and you have the occasion to talk. It's up to me. It's the remaining task for me to thank you all for contributing to the discussion, to engaging yourself and being here. I want to thank our Vice President for hosting us. I want to thank very much the Mercator Stiftung for supporting us, because we could not do this lecture series without them. I'm very grateful to the Dynamint Graduate School with Dr. Spieker, who organized the conference. Thank you to all visitors of the conference. And please, a special applause for the assistants who were organizing the speech, because that is very cumbersome. So. But of course, although I'm very happy with this great applause, the greatest thanks go to our speaker from this afternoon. We have a little gift for you. You may enjoy that. This is a line of Humboldt speeches with people like Emmanuel Macron, Olaf Scholz, and so on. You may enjoy.
Thank you.
Thank you for being open to.
Thank you very much for the excellent speech.
Thank you.